the badge in his face, and I says, the badge says, see Glendora on NBC, and that my relationship to NBC is that I'm a customer of NBC. I buy their airtime. I think I bought, let's see, I bought 19 spots on the NBC television network, and I think it came out to $25,000 for the first 10, and maybe and $37,000. I think it's about $37,000. And Silverman seemed to be enlightened by that. His eyes opened a little bit. He talks. He mumbles too low. Mumble-o. There was a man in Buffalo named Mumble-o. He was a minister, and he had a son named Mumble-o, who was also a minister. I don't see how Kalaji gets by with his 30-day stay, or how many days it is, without putting up an undertaking. I say that pro se is not a stigma. I say esquire is a stigma. The Kalaji got in the thing again, the other lie that personal disputes should not be on television, and that's why Cablevision took the program off the cable. Well, they don't have to have a reason why. Just the fact that they took it off was censorship, and censorship is prohibited in New York State on public usage channel. What was I going to tell you? That television was no place for personal disputes. I said, well, Judge Silverman, then they've got to take court TV off of television, and they have to take the network coverage all day long, all week long on O.J. Simpson, because the O.J. Simpson case and the court TV cases are all personal disputes. Folks is waiting for this decision of Judge Silverman to be in writing and be mailed to us. And then he gets up and leaves Fridays. He's gone Friday, Saturday, Sunday, Monday, Tuesday, and Wednesday to a seminar. You want to know why cases take 7 years in the Supreme Court? Well, I hope that these judges learn something at these seminars, but I doubt if they do. It's pretty much a partying affair, I suspect, don't you? And an excuse. And you want to know why the law clerks have such power in the Westchester County Supreme Court. I think it's because the judges don't like to do their work, and so they are dependent upon the law clerks to do the work, and so then the law clerks become very self-important and start bossing the rest of the public around, as long as they're going to boss the judges around. Let's see. Judge Silverman did not say anything about costs. And I'm told that if he was silent on costs, we'll have to wait for the written decision. Then I can get costs. And the cost would be $170 to buy the index number, $75 to buy the judge, the request for judicial intervention, and I guess that would be it, $245. What were the comments on it? Somebody said, you carried yourself well, very well. Oh, yeah, he did. He did put me in contempt. And then at the end, he said to Rochelle, the court reporter, I'm granting the application for a stay. See, that again is pro-defendant, pro-Park Avenue, pro-lawyer. He just granted it right then and there, orally. And then he said, take off the contempt. He relented on the contempt, so I didn't go to jail. And I wasn't put in handcuffs. That would have been quite an experience. That really would have been something to do a chat with Glendora from jail for standing up for my rights in court against a prejudiced judge. Well, I guess he really didn't want it on his, he didn't want the publicity. Somebody else said, I asked somebody else, did I put up a good fight? And that person said, definitely. There's one comment that came from somebody down at the appellate division in Brooklyn that was really good. And when he said that, he said it, I don't know if you can really tell the amount of meaning that is in this. He says, I can tell you that's quite an accomplishment. You were successful. And I think what I read into that, folks, is that for pro se to win is an accomplishment anyhow, because there's this ingrained prejudice of judges against pro ses, which is unconstitutional because a person has a constitutional right to be a pro se. And I think also what you can read into that I stood up to Cablevision, a huge company, multi-billion-dollar company, that I caught them breaking the law. I caught them lying. Cablevision was caught lying. There it is. The decision is there. Cablevision was caught lying. They lied and they were caught at it. And also, I read into that statement would be to win against a 230 Park Avenue law firm. I can't think of anything else to say about that. Can you? About what happened in Judge Silverman's courtroom on July the 14th, 1994, from 10:15 a.m. to 10:48 a.m. I asked Rochelle how much did she think the minutes would be. I didn't ask her that. I asked her how many pages they were, because I can calculate how much it should be. And she says it's about $150 if you don't rush me. I think that's it, folks. For you, that if you know the law, you hammer the law. If you know the facts, you hammer the facts. And if you don't know either, you hammer the table. And if you can't get a lawyer who knows the law, at least get one who knows the judge. And how can a lawyer, or myself included, write a document of 5,000 words and call it a brief? Oh, you'd be amazed to see the records on appeal that these lawyers hold up when they're before the appellate division. Some records on appeal are this thick, this thick. And then George asked Bill, he says, how much money do you have in the bank? And Bill says, I don't know, I haven't shaken it lately. And did you know that the left side of the brain controls the right side of the body, and the right side of the brain controls the left side of the body? You know what that means? That means that only people who are left-handed are in their right minds. So this same day, July the 14th, 1994, it's horrible. You know, it's one legal paper to get out a day, and sometimes more than one. And today was more than one. And that was on modern courts, and the legal paper was to Judge Colabella. So I'll have to tell you about that later. I have to read you the letter that the lawyer for the Fund for Modern Courts wrote. A letter, mind you. The name of this lawyer is Edmund S. Purvis. He's at 1690 Palmer Avenue in Larchmont. And he wrote a letter to Judge Colabella as to the irrelevant, repetitive, and libelous statements made by Glendora, and both were for affidavit in opposition to defendant's motion for summary judgment. And in her notice of cross motion, defendants will not dignify them with a reply. That's such a trite phrase. Defendant's position has been clearly set forth in the affidavit in support of the motion in the accompanying memorandum of law. Okay, this is my answer to that. Several pages. In fact, I don't know, looks to me like 30. Supreme Court of the State of New York, County of Westchester, Glendora plaintiff against Elizabeth Hubbard, Alan Beck, Michelle Mayapath, and the Fund for Modern Courts defendants. Index number 2086793, Plaintiff Glendora's reply affidavit to Purvis' improper letter of July 11th, 1994, Monday, with an order form requesting Judge Colabella to sign. Honorable Nicholas Colabella, Glendora being duly sworn deposes and says that her reasons follow for opposing Purvis' letter of July 11th, 1994 to Judge Colabella, and for the order form she requests Judge deposes and says that her reasons follow for opposing Purvis' letter of July 11th, 1994 to Judge Colabella. And for the order form, she requests Judge Colabella to sign. Point alpha, Purvis does not write a grown-up legal paper. Courts are not run on letters. Courts are run on legal papers. Motions, cross motions, affidavits, reply affidavits. This is as nascent as his calling his memorandum of law a brief. Point beta, irrelevant is a lie. Every statement in Glendora's cross motion was altogether too relevant. Defendant's lawyer can't take the heat of the truth being told. Point gamma, repetitive is a lie. Colabella simply dealt head-on with every false statement. Glendora, excuse me. Repetitive is a lie. Glendora simply dealt head-on with every false statement Hubbard and Purvis made. I hope Colabella does too. Point delta, libelous is inaccurate. It is libel only when it is not the truth, and Glendora is privileged, absolutely privileged by the New York State Civil Rights Law, section number 73. Point epsilon, quote, will not dignify them with a reply, unquote, is a platitude, a dodge, a rationalization, a runaway. There really is nothing defendant's lawyer can say to the truth. Point zeta, Purvis finally calls his paper what it should be called, a memorandum of law, quote, unquote, instead of calling it a brief, unquote, unquote, quote, unquote. Point eta, his letter is not signed. Point theta, Purvis does not refute one point of Glendora's cross motion, so Glendora should win by default. Point iota, defendant's lawyer made their ridiculous affidavit in brief, quote unquote brief, and motion for summary judgment entirely as a manipulation to avoid discovery. Point kappa, it is a public disgrace, and Glendora has read the record on TV, on 9 cable TV companies, including TCI and Manhattan Cable TV. Point lambda, in addition to being fugitives from service and fugitives from discovery, defendant's lawyer are fugitives from judicial conferences. Point moot, behind plaintiff Glendora's back, defendant's lawyer call up the law clerk and manipulate their escape from conferences. These conferences were called and they squealed out of every one. 3 conferences were called and they squealed out of every one, June 16, June 21, and June 22. This is a disgusting record. Point new, their lying, stealing, and cheating about the cause of action of Glendora's lawsuit also is a disgusting record. You monitor the courts and write your reports, and at the end of the monitoring period, we will publish our report. That's what they said. Glendora and Franklin did their job, but the defendants did not do theirs. Point I, Purvis writes in his brief, this is a court of equity. Black's Law Dictionary says states that have civil practice laws don't have courts of equity. Courts of equity in brief, what century do these belong to? Point omicron, there can be no summary judgment in favor of defendant's lawyer because 1, defendants have no meritorious defense, 2, and never will have nor can have, plaintiff believes. Point pi, no conferences, no discovery, everything is on paper, it is like a correspondence school. Point rho, it is a simple case. Defendants asked Glendora to monitor courts and write reports. Defendants said they would publish a report at the end. Glendora and Franklin monitored the courts and wrote the reports. Defendants did not publish a report. Point sigma, would Glendora and Franklin have worked all those hours, spent all that money for gasoline, parking, postage, paper, and copying if defendants had said in the beginning, we are not going to publish a report at the end of the monitoring period? Would we have? Point tau, Glendora's cross motion submitted June the 21st, 1994, after 72 hours of hard work, says it all. Upsilon, Your Honor, Glendora has an order pursuant to CPLR Section 3213 she would like you to sign. It is for accelerated judgment. I will read you the order that I hope Judge Colabella signs. Supreme Court of the State of New York, County of Westchester, Glendora plaintiff against Elizabeth Hubbard, Alan Beck, Michelle Mayapath, and the Fund for Modern Courts. Defendants, index number 20867 of 93, order granting summary judgment for plaintiff in action based upon a judgment. The plaintiff in the above entitled action, having made a motion for an order pursuant to Section 3213 of the Civil Practice Law and Rules, that's accelerated judgments, directing that summary judgment be entered herein in favor of the plaintiff for the relief demanded in the notice of motion served upon the defendant with the summons in this action on the ground that there is no defense to the action. Now, on reading and filing the notice of motion dated June 20th, 1994, this, we hope, is what Judge Colabella is going to sign. with proof of due service thereof, together with the summons issued November 16, 1993, with proof of due service thereof. The affidavit of Glendora sworn to June 20th, 1994, in support of said motion, and no affidavit of defendants in opposition thereto. See, that was the letter instead of an opposition. And after hearing Glendora, plaintiff pro se, in support of said motion, and Edmund Purvis, attorney for the defendants, having submitted no opposition thereto, and due deliberation having been had, it is, on motion of Glendora, plaintiff pro se, ordered that said motion be, and the same is hereby granted, with cost of $170 fee for an index number and $75 fee for request for judicial intervention, cost of this motion, and it is further ordered that the plaintiff have judgment against the defendant in the sum of $20,000 with interest thereof from October the 1st, 1993, and that judgment be entered accordingly, signed this blank day of blank July, I hope, 1994. At White Plains, New York, enter Nicholas Colabella, Justice of the Supreme Court, Westchester County, to Glendora, Box 416, White Plains, New York, 10602-914-9495. Edmund Purvis, Esquire, 1890 Palmer Avenue, Larchmont, New York, 105-83-914-834-0100. Elizabeth Hubbard, Allen Beck, Michelle Maypath, Fund for Modern Courts, Suite 310, 36 West 44th Street, New York, New York, 10036-212-575-1578. That's the order. And then I have to close my paper because it's an affidavit, White Plains, New York, July 13th, 1994. Glendora, subscribed and sworn to before me this 14th day of July, Francis Harrising, and it's to all of those people I just read you. And this was handed in at 11 a.m. on July the 14th, 1994. It came out of Judge Silverman's courtroom at 10:54 a.m. and I went down to the 16th floor where Judge Colabella is. That's the affidavit of service on the other side, and I handed in this paper. And here's all the exhibits. Would you like to know what the Fund for Modern Courts said about Judge Colabella? He received his undergraduate degree from New York University and his law degree from Albany Law School. From 1981 to 83, he served as East Chestertown Justice. In 1983, he was elected to the county court, where he served until 1988, county court's criminal, when he was elected as a Republican to his current post as Supreme Court Justice. Monitors observed Justice Colabella 7 times on 3 different days and described him as very courteous. I think I was 4 of those days, or 4 of those times. Dignified and compassionate. The judge's demeanor was informal and unpretentious in manner. His temperament seemed low-keyed and cordial. Wrote one monitor, he appeared attentive during long testimony but spoke little. While he used his microphone regularly, one monitor wrote that his voice was sometimes too low and inaudible for the rear of the courtroom. Monitors agree that Justice Colabella ran court smoothly and made sure everyone present understood what was transpiring. He explained rights to defendants and frequently stopped to explain proceedings to jurors. His explanations to jurors were clear and to the point. He treated attorneys professionally and, when necessary, quietly admonished a defense attorney for wasting court time by obtaining documents that should have been procured earlier. He put on a good show for the Fund for Modern Courts, didn't he? Justice Colabella took the bench at 9:30 a.m. on 2 of the 3 days he was observed. On the other morning, court began at 10 a.m. The judge explained the delayed opening. Wrote one monitor, the judge was conscientious about giving reasons for delays and recesses during proceedings. Rating of Judge Colabella: 5 is the best you can get, okay? He speaks clearly and audibly, 4.4, prepared, 4.5, punctual, 4.3, allows equal and adequate time for all parties, 4.6, allows equal and adequate time for all parties, questions before granting adjournments. I think that's a mistake, modern courts. 4.3, gives clear explanations, 4.4, takes appropriate recesses, 4.4, gives reasons for delays, 4.6, listens well, 4.6, Patient and considerate, 4.6. Appears compassionate, 4.6. Dignified, 4.7. Maintains order and control, 4.7. And then Honorable James R. Cowie is the next judge's report. And Judge Carey was the judge before that. Well, after the monitoring period was over, I went in and watched Judge Colabella, and I saw a little bit of relaxation on all these wonderful accolades, like not getting there on time and not being polite. Okay. After Judge Colabella on July the 14th, 1994, Thursday, and after Judge Silverman, I went up to Judge Wood's robing room to see John Sulich. I told John Sulich that asked him if he'd heard from the other side. No, and I reminded him again that I didn't want any more adjournments on this date certain to be set for discovery to be finished and get this thing into the trial assignment part. And Judge Wood says, Glendora! And so we had a talk about, of course, non-lawsuit things. The rest of Thursday, I had to edit. And I edited at TCI with Franco from, I get there about 10 minutes to 4, and I leave at about 7:30. And Jean-Claude gave me an extra 7 minutes to finish archives dub, a VHS archive dub of the of some program. It would be 1525. So we did quite a few programs. I wrote them down here for you. We did 1522. 1521, unfortunately, was by mistake sent to a cable TV company to be cablecast, and it needs 10 minutes of archive. And it should have been done before it went out, because what happens if, what do you do if something happens to the original? You don't have an archive. So 1521 couldn't be worked on, but we did 1522, 1523, 1524, 1525, 1526. And Franco is very good at what he does. He's very, very good as a public access coordinator. And of course, every day I try to read 5 pages of discovery. That's from the CPLR, Article 3100. And also, where are the interrogatories in Article 30, I guess. So I'm pretty much up to date on that. Missing Thursday and Friday, I believe. No, Wednesday, too. Alrighty. And let's open up the desk drawer here, my naughty Cypress desk, and tell you about some jokes. A little boy, not a little boy, a teenager was asked in science class, what do you know about the speed of light? And the student says, nothing except that it gets here too early in the morning. And teenagers really brighten up a home, don't they, folks? They really brighten up a home, teenagers, because they never turn off a light. And the Little League, oh, this is good, that Lincoln, Abraham Lincoln once walked 9 miles to return a book. And today, on his birthday, we celebrate his birthday by closing the libraries. Little League is where the kid on the mound has 5 pitches. 5 pitches. A fastball, a slow ball, a curved ball, a sinker, and one that you hope reaches the plate. So this is what happened on Glendora versus Elizabeth Hubbard. Let's start over. This is what happened on Glendora versus Elizabeth Hubbard, Alan Beck, Michelle Mayapath in the Fund for Modern Courts on the week from July the 14th to July the 21st, Katie is here. That's the end of her tale. Wish the end of my tale was here. A woman told me last week that she likes to watch the cats on the program. Several people have said that they like to watch the cats on the program. Okay, I wanted to read to you From Black's Law Dictionary, what a court of equity is. A court of equity which has jurisdiction in equity, which administers justice and decides controversies in accordance with the rules, principles, and precedents of equity, and which follows the forms and procedure of chancery, as distinguished from a court having the jurisdiction, rules, principles, and practice of the common law. Just a second. I'm sorry about that. She would have pulled down the curtain. She wanted to go up on the window. She was climbing the wall, going up to the windowsill. Okay. As is distinguished from a court having the jurisdiction, rules, principles, and practice of the common law. Equity courts have been abolished in all states which have adopted rules of civil procedure. That's us. That's we. Which have adopted rules of civil procedure, law, and equity actions having been merged procedurally into a single form of civil action. See the Court of Chancery. That's the term that Purvis, lawyer for modern courts, misused. He called Colabella's court a court of equity, but courts of equity have been abolished in states that have adopted rules of civil procedure. We have the CPLR, civil practice and laws. Now, also, there's another thing that Purvis did that was wrong. Use of interrogatories. After the commencement of an action other than in an action to recover damages for an injury to property or a personal injury resulting from negligence or wrongful death, any party may serve upon any other party written interrogatories. Well, he shouldn't have served upon me written interrogatories because this was a personal injury suit. That's another law you didn't know. Here's a third one. After commencement of an action, any party may serve upon any other party written interrogatories. How is that different from use of interrogatories? That was 3132. All right, let's go on. If service is made by any plaintiff upon any defendant within 20 days after service upon him of the summons and complaint, or service is made by any defendant upon the plaintiff within 5 days after service upon him of the summons and complaint, leave of court granted with or without notice must be obtained. So, and it wasn't served upon me within 5 days. She says June, July, and August. Franklin typed the 2 pages of statement of facts this morning at 6 a.m. There is nothing new on the docket in the Westbury bankruptcy clerk's office. Bert Patterson was not in. There is no final accounting yet. Karen Sherry does not know anything about it, and the Hempstead police investigation They will investigate 17 Center, right around the corner from them, about Scott Lord running a business without a consumer affairs license. Glendora. Written complaint. So I sent that to them. I sent a copy to Judge Colabella too. Those are 3 things they didn't seem to know. Now what else happened on Friday, July the 15th, 1994? There's no decision down at the appellate term on Brower that the appeal should be discontinued and the undertaking paid to Glendora, the undertaking being only the amount that Judge Noka awarded me in the first place. Cablevision stock went way up to $50.75. Wow. TCI is at 14.5, and Gannett Company Incorporated is at 50. I told the campaign people for Pataki, who was running against Cuomo to be governor of the state of New York, that grist for their campaign mill is certainly the DHCR case. I really got to send a copy of that to them. The negligences of the DHCR and Ayala and Cuomo and Fernandez and Short and Mays and later on Stephen Cohen, Gary Friedman, and all of those people, which is a lawsuit we'll read you next week, the brief for that. There were 200 telephone calls Friday. I talked to Fred Shapiro. I told Fred Shapiro that if I was going to look in on his class at Pace University on New York law, that I'd better do it Monday or Tuesday because he's through on Tuesday. And he says, oh yeah, he says, I talked to the registrar and she says you can't do that, that you can't look in on a class. And it seemed to me like Fred was looking around for a way to get out of it, and I don't know why he should, because the director of admissions told, or a person working in that office told me that I could do it, and I told Fred. So Fred at the moment is squelching my going in and watching him teach his class for a few minutes on New York law. That's Fred Shapiro, who's running for county court judge. And that's Katie Cat, who's running for food. The details got done Friday from Scott to Cablevision. That's Scott, Broda, Esteves, Lydia, Wall, Brower, Modern Courts, and Cablevision. And a chat with Glendora got indexed. On Saturday was the Buell reunion. I showed you a lot of pictures of that way up in northeastern Connecticut, up where at Rhode Island, Connecticut, and Massachusetts all come together, right in a square, in a corner. We picked up the Lincoln Friday because John Idice hadn't finished it. I read the discovery on the way. The Lincoln went 125 miles up there to Connecticut and 125 miles back, and it bucked 60 times. And that should not be. You know, this is after this thing of bucking happened, after the rebuilt engine was put in. And it's bucked ever since, and I've taken it and talked to Rick about it 6 or 7 times, and it still bucks. We painted 2 file boxes red on Sunday. You get nice file boxes, copy paper boxes from Office Max, but they have printing on them. They don't look good when you file them away, so we painted them red, 2 of them. We took the Folsoms, or we watched Robert Schuller Sunday morning, Crystal Cathedral church service on TV, and then we went to church and we had punch on the lawn. And I told several of the lawyers who belonged to our congregation how I'd won the cablevision case. That cablevision has to put my program back on TV in Nassau County. Then we picked up the Folsoms. He's 91 and she's 90. And we went over to the minister's wife's house, and I washed the bird bath, made it all nice and clean, filled it, and Franklin watered the the plant beds. And then I did Brodus Davis, Cupola 1 brief for Friday, Saturday, and Sunday. We went to Pathmark. Don't go to Pathmark on a Sunday night. It's terrible. They haven't got the shelves stocked. It's just awful. And then I came back and I did Lydia, and I did the wall log and started the envelopes, and Franklin typed the Cupola 1 brief, Francisco. And check TV. Isn't it great about all of the coverage that's on the comments hitting Jupiter? It's something that they said you wouldn't see in a million years. And we are seeing it. That's great. It's too bad that the comments are hitting Jupiter, I guess. But then Jupiter is really a ball of gas. Like some of the people we see in the courts, right? And on Monday, 5 to 5:30 a.m., we did that, and I watered the Young's plants. I finished the wall envelopes. We put a copy of the Weber complaint into each file, and we put the last page of the logs into the telephone file, so that as things develop over the telephone, we can make the entry right then and there. I've been called for jury, and you call a number there, and my jury number wasn't up, so I didn't have to go in Monday. And it was raining hard, too wet for John Idice to paint the Lincoln, and we kept the Cupola 1 reply brief, Francisco, all of his lies. We kept our writing of that up to date. Together a report as to what happened in Judge Silverman's courtroom when he said that I had won the case. I'm reading the Cablevision proxy statement, and I read some of the parts to you. I'm looking up appeals generally to see what can be done about a stay. And Janine Pirro called me. She's our Westchester County District Attorney. And she called me, and I told her how I won the Cablevision suit, because, you know, they did the same thing to her back when she was running for District Attorney. Cablevision Harrison took her program off the cable. And she said she didn't have time to fight it at that time, and of course she didn't. Well, I fought it, and I fought it as a class action. And it covers every public access producer in the state of New York. I called the appellate division, and they have no decisions yet on Nikolai, Ruskin, and Donovan. Now, let's see, I started answering the Cupola 1 brief, Sanders' part, who's defending Governor Cuomo from negligence. And I learned how to shorten the post on my TV light, thinking that it would get rid of the shadows, but it hasn't. I can't get rid of that shadow. I only have one light, you know. Cupola 1 brief, reply brief, as far as the Francisco part goes. And on Tuesday, Franklin took it to Office Max, and he had it copied, and he had it bound. And I pretty much finished on Tuesday the Cupola 1 brief answering Sanders for Governor Cuomo as a defendant. There was the noisy Walsh gang on Tuesday. The details got done scot-through, Brower. And a chat with Glendora was on TCI at 9 p.m., Channel 8. And it was about Cablevision. On the telephone, and they tell you if your number is between so-and-so and so-and-so, don't come in. And I didn't have to go into jury duty on Tuesday either. Wednesday was a big job. we called, and I had to go to jury on Wednesday. And John Iodice said that he would paint the car, but then when I called him up, he said he couldn't paint the car. And so I had to call up Enterprise again, and I had to cancel my reservation for a rental car. Big job on Wednesday was getting to jury. And one good thing about being on jury, you can have a parking space. You go into the county courthouse tower, and you get into a nice parking space. And then came along and said, "You can't park here, only jurors can park here." And I said, "Well, look at the dashboard, and that's where you put your summons." And he says, "Well, is that you?" And I said, "That's a dumb question." "She sweet?" "No, she's a bad kitty." "Oh, you are? You're a bad kitty." "Oh. You just ate. I just fed you 4 times. Here, sit down. Thank you very much." Thank you very much. Just for that, I'll scratch your ears. Well, what was I telling you? Okay, and then you go up to the second floor to where what we call the ceremonial courtroom, which they call the central jury room. And you hand in your paper that they send you to fill out. And it's really your pay slip. And then I went into the central jury room, which was really the ceremonial courtroom. And it was funny for me to go in there because there was no appellate division. Always before when I've gone into that room, there's been an appellate division. And so some kind of a deputy commissioner of jurors came and spoke to us. Teresi, I thought she was very good. But you can't hear anything in that room. The acoustics are terrible. The ceilings are way, way too high. You can't hear a thing. The ceilings are way, way too high. You can't hear a thing. The time is 5:15 p.m. The date is July the 22nd, 1994, and it's Friday. And these are 6 noisy girls breaking the White Plains noise ordinance. Also playing on the lawn, which the landlord doesn't want. Time is 5:54 p.m. The date is July the 22nd. It's Friday, and it's 1994. That is Kevin Larkin, and that is James Walsh. anymore. They used to be. Darrell was the worst one. As you wait for them to come, you sit on the steps, and the door is straight ahead of you, and when somebody comes in, the light is behind the person, so that all you see is a silhouette. And I always say hello to everybody coming and going. That's the only thing I could think of. That I never saw his face, actually. He saw mine because the light was on my face. I didn't see him because the light was behind his head. Okay, and so at 12:27 was lunch, and then I hastened to UPS, where the 10 appellants' briefs, Glendora versus Dolan, Tata, Lusgarten, Randolph, etc., were shipped to the U.S. Court of Appeals to appeal the very bad decision of Judge Broderick. Now, here's Judge Silverman, had the same law in front of him practically, and naturally he rules that the program has to go back on TV, but Judge Broderick didn't. And so that got shipped, and also a copy to the Kalaji at Park Avenue, and then came back here. And when I came back here at 1:15 p.m., my kitchen linoleum was missing. That means somebody had entered my apartment and taken the kitchen linoleum. Where? I don't know. Also, the sink countertop was all waterlogged and swollen with water, and the cutlery drawer was all had water in it. In fact, it was so swollen that you couldn't get it out. And then underneath the sink, there was water in the little stacks of refrigerated dishes, and there was water in the pan that was holding different cooking ingredients, and there was water in all of the other big refrigerated dishes. Okay, what happened? Who did that? What is your feeling about that? What is your suspicion about that? Okay, next week I'll talk to you. I haven't had time to investigate it yet. My suspicion is that it's vandalism, that somebody came through the screen, came through the window, and deliberately put that water in those places and took the linoleum, which we found in front of our bin downstairs. So I think it's vandalism, and we have to find out who did it. But you know who the prime suspects are. So I'll report to you on that next week. The bin, the cellar light bin has been fixed. It's beautiful. Cesar did it. Mr. Porzio was here. And he's here showing people some apartments for rent, either Building C or Building D. And then I went back to jury. I had to rush back there at 2 p.m. and we sat in the ceremonial. We came into that room, and then after sitting, just sitting there for 20 minutes, boy, do they waste time. Everybody's time. So after sitting there 20 minutes, a woman came in, a clerk, and she wanted to see me and Mr. Schomburger, who was the only two left of that first 6, and said that we had been excused. Why do they say excuse? You haven't done anything wrong. And so that's a queer thing, why they did that. But, lawyers are queer anyhow. And so we had to go back to the ceremonial courtroom, because if you don't get chosen for one case, and then you go back and then they have another case. So finally around 3 o'clock, they came with some more names and put them in the drum and drew out the names, and then we were all called to go 2 by 2 back to another interview room. And when we went in, there were 3 lawyers there. One of the lawyers was looking at me intently, and about 2 minutes later, all the lawyers got up and left. And the next thing that we knew, or I don't know if it was right or not, but 8 clerk told us that the lawyers were having a conference with the judge. So we waited from 3 o'clock to 4 o'clock, doing nothing. And let me tell you, the rest of the people are really quite unhappy about this. They're quite tense about it. How it sits around, do nothing. Wait and wait and wait. And then at around 4 or 4:15, this same clerk came in and said that it was going to take too long to have the conference, the lawyers and the judge, and that we could go. and everybody left, and as I went out the door, the clerk was saying to one prospective juror, well, I have a feeling that they won't be calling you in tomorrow. I have a feeling that you will be, all of you will be dismissed, because we have other jurors that we've called in that we haven't even talked to yet. Then sure enough, Thursday morning when we called on the telephone and listened to the recorded announcement, we all had been dismissed. Crazy? You know, I had enough complaints about the courts. You know, I didn't need to be called a juror and see all that. Of course, we had a terrible mess to clean up in the kitchen. That took a long time. And we'd work on that for 10 minutes. But it's all out now, and it's all washed. Everything, I washed everything. We dried it. And all the articles that were in those cupboards and drawers are dried. But the cupboard itself, under the sink, you know, it's made out of that composition kind of stuff. And I really think it's just compacted paper, isn't it? And you know how long it would take a pack of paper that was solid wet to dry, and so it's still drying now on here on Thursday morning at 11:50. So anyway, last night we got the Coppola 1 Sanders part of the reply brief done. We typed the table of contents and we repaginated it and we made a title page. And this morning Franklin did his affidavit of service, and we're hopeful that that will get out this afternoon, which is July the 21st. 1994, Thursday. Now let's open the joke drawer here, and let's find you some jokes. I collect these jokes for you. Then I write some of them. At the lodge meeting, the announcement was made, we regret to inform you that the grand, invincible potentate will be unable to attend the meeting tonight. His wife won't let him out of the house. And Marilyn said to her husband, George, that's the 7th time that you've gone back to that buffet table for food. Aren't you embarrassed? And he says, oh no, honey, I keep telling him it's for you. And Bob said to Elaine, when are you thinking of getting married? And Elaine said, constantly. Thursday morning, I didn't have to call to see if I had to go to jury because it's over. But I called John Iodice. It's a beautiful, bright, sunny day, and he's not going to paint the car today. I tell you, he's the best body man there is, but he's the slowest. And so now he promises Monday he will do it. In the meantime, I'm driving around a Lincoln with the whole driver's side beautifully patched and beautifully undercoated and ready to paint, but it just looks terrible. And so I had to call Enterprise again. I talked to Lee Kai, and I had to tell her again that I regretted postponing the reservation to pick up a car, and that'll be on Monday. So we'll see if John Iodice... What if it rains on Monday? Well, we'll see. John Iodice. 4 hours so far to do the videotaping for this week. Todd, whom I like very much at Cablevision Harris in Port Chester, made an appointment at 4 p.m. to pick up 4 programs and to bring in 4 more programs. Versus Richard O'Connell and Jeffrey Barnes and Jan Stahl and Scott Lord. Unfortunately, Lisa Shrewsbury sent in a respondent's brief, and I almost think it would have been better just for them to let it go, and then I would have asked them if they would have paid their quarter of the costs, and if the other 3 defendants would have paid, and respondents would have paid their 3/4 of the costs, and we would have dropped it. But now we're going to go through with it. and I will have to answer this, and it is only 6 pages. So it's kind of too bad. So that's, and before I answer that brief, I have to write a reply brief for Coppola 2, Judge Coppola's second bad decision. And that, of course, is the respondent's brief written by Sanders again, the Assistant Attorney General. And so I will have to answer that one first. Speaking about briefs, that would bring us into, that's what happened on Glendora versus Scott Lord, July the 14th to July the 21st. And then over on Broder, what happened there, I think all that's going on there is that we are waiting for Kalaji to get in his respondent's brief. It's ordered by the United States Court of Appeals that Kalaji have that brief in by the 27th of July. That's about 10 days. And then I will have to send out a reply brief to that. And then what is happening on Glendora versus Lydia Gallicano? The appellate term did receive my motion to discontinue the action because John Ornberger can't get around to signing his name to the stipulation, and that would have ended it. So now we got to wait 9 weeks for a decision on that. It's too bad. That's he's wasting the court's scant judicial resources, so to speak. That's what happened on Glendora versus Lydia Gallicano, July 14th to July 21st. And that brings us up to Glendora versus Daniel Walsh, Roberta Walsh, James Walsh. His mother calls him Jamie, his father calls him Jim. Nella Alpucci, Theo Alpucci, Kevin Larkin, and Andrew Larkin. I am thinking of seeing Judge Wood and joining in a couple of more names on that lawsuit. That would be Neil Alpucci and Ferdinand Alpucci. This is mailing number 73, and there's 713 tortious acts. This is for the week of July the 18th, 1994. What happened at 21 Greenridge Avenue, White Plains, New York, 10605. On Saturday, Glendora watered 2 plant boxes and 1 plant pot for Mr. Young in 2B. And at 5:30 a.m., a man in 3B has a car and his exhaust system is ruined, and it's against the law, and it's causing noise and air pollution. He cuts across the lawn and is also killing the grass. The Walsh family is away. Glendora did the wall envelopes. That takes about an hour. At 1:15 p.m. there was a heavy rain. It started at 8:30 a.m. Johnny, he's the repairman for the washers and the dryers. He's very good. He came to fix the washer and the dryer. He immediately goes to me and he says, "What happened?" And I said, "I don't know. I did not call. I didn't know that it was broken." And I went down cellar. Johnny went down cellar and I went down after him to see if I could help him. And Nella Alpucci was there, and she started her abusive and insulting language, so I left. And at 1:32 p.m. Johnny left. Apparently had been fixed. At 1:30 p.m. the Walsh family was back, and this is on Saturday. And on Monday, the July 18th, District Attorney Janine Pirro returned Glendora's call, and Glendora told her she had won the Cablevision case, that Cablevision has to put Glendora's program back on cable TV in Long Island. And there was a lot of noise from 2:30 to 3:40, 6 p.m. 3 p.m. Porzio was here, John Porzio, to show couples some apartment for rent, either in Building D or Building C. At 5:30 p.m. Monday, A Chat with Glendora was on Channel 14, White Plains, public access. That's a good good little cable operation. At 3:40 p.m., Kevin, James, Brian, Larkin made outrageous noise. I showed you that on videotape, and it will be cable cast. 11:27 a.m., Peeping Tom, James Walsh, looked into our south bedroom window. At 12:05 p.m., there were noisy girls playing ball on the lawn, and the landlord does not want anybody playing on the lawn. And there was a breaking of the White Plains noise ordinance. That was Roberta Walsh and Candy Alpucci at 4:19 p.m. I was working at my desk by the south window. Roberta Walsh and Alpucci went by, and Nella Alpucci said, "Hello, F-U-C-K, F-A-C-E, it's howdy doody time." And that's on July the 27th, 1994, on Wednesday. Insulting and abusive language, harassment, intent to cause emotional disturbance, and totally unprovoked. Nothing was said to her before, during, or after.
I'll see you later, okay? Candy, would you look at this? You're a sick woman, you know that?
That's Roberta Walsh. The time is 4:20 p.m. The date is July the 27th, 1994, Wednesday. Immediately following Nella Alpucci's lawbreaking. Hi there, everybody. We start a new week of A Chat with Glendora as we wander through purgatory, which is my name for the New York courts. Dante wrote the Divine Comedy in the 12th century. Believe me, he ain't seen nothing yet of going through purgatory and going through hell. This is, let's start off with some jokes here. Peter says now that he's married, he knows why they call English the mother tongue. Father never gets a chance to use it. And for their wedding, Mark and Sally got several gifts, folks, that said his and hers. And they got one gift that said us, the United States Army blanket. And Paul says his favorite trick is to run his videotape, his wedding videotape, backwards, so he can see himself walk out of church a free man. New York Supreme Court, Appellate Division, Second Department. Glendora plaintiff appellant against Stephen Cohen, Myron Holtz, Gary Friedland, the William Street DHCR, John Wallach, Veronica Diaz, the Queens DHCR Pardock at defendants' respondents. This is an appellant's reply brief, Glendora Pro Se, Box 416, White Plains, New York, 10602, 914-949-9495. Westchester County Clerk's Index number 11357 of 93. And the case number in the appellate division is 1993 year, 08945, to be argued by Glendora, 15 minutes requested. This is the reply brief to Judge Coppola's bad decision number 2. And this is the table of contents. The attorney for the defendants is Charles Sanders, who is an assistant attorney general of the state of New York. This is still the table of contents, and it lists the points. End table of contents. Argument, point alpha. Sanders can't get it right the first time. He sends out a brief for defendants' respondents. 2 days later, he has to send out a corrected brief. Now, doesn't this win Glendora's case of negligences for her? Glendora told Judge Coppola the defendants were negligent. Now they show the appellate division they are terminally negligent. Point beta. Glendora refuted every citation in defendants' respondents' table of authorities. Please see the record on appeal, pages 116 through 138. Glendora checked out every citation of Sanders. She was 40 hours researching these in the Pace Law Library, copying them, reading them, and arguing them. Many of them were irrelevant and applied not to Glendora's cause of action. Many of them were in Glendora's favor and were against the defendant's case. All of them were old and used year in and year out for a decade by the Assistant Attorney Generals long before Sanders. Many of these decisions were partly made by Judge Wackler, a guest on a chat with Glendora 9 days before he was arrested by the FBI. Former Chief Judge of the state of New York, who is now in federal prison. Glendora's point is that these citations have no value against Glendora's action. Point gamma. Plaintiff appellant Glendora objects to Attorney Sanders calling defendants the state defendants. Glendora will call them the Stephen Cohen defendants. State defendants is a manipulation trying to prejudice you four judges of the appellate division that these 7 defendants are not accountable for the wrongs that they did and trying instead to blame their actions on New York State. Point delta. Stephen Cohen defendants, lawyer Sanders, have the wrong name for the plaintiff appellant in their preliminary statement. The correct name is Glendora. Respondent's lawyer cannot read a caption correctly. This is just another negligence. Number 20. Point epsilon. Judge Coppola, for the 28 reasons stated in Glendora's appellant's brief, was wrong to deny. Glendora's cross motion was wrong not to award Glendora $50,000 damages for injuries caused her by Cohen respondents, and was wrong to dismiss her case, just as he was wrong to dismiss the first DHCR case. Point zeta. Glendora answers Sanders' questions presented. Questions presented. This is what Sanders writes. Whether the complaint failed to set forth a legally cognizable claim sounding in negligence as against the state defendants. Glendora, the complaint absolutely did, and Judge Coppola was wrong not to grant Glendora the relief for which she sued. Whether the court below lacked subject matter jurisdiction to award money damages against the state defendants. Glendora, this is a Judge Coppola escape. A good judge would have seen through the respondents' lies and those of their lawyer and had awarded Glendora the relief, $50,000 she was due. I'm so glad that Judge Coppola's term is up. He's running this November, and I will not pull that lever. I would not vote for him. Point eta. Glendora protests Sanders' statement of lies wrongfully submitted to the appellate division as a statement of facts. He says, on October 19, 1992, plaintiffs brought an harassment complaint before the division concerning actions taken by Jose Esteves, the owner of the premises where she resides, he says. That was a long time ago. That was in 1992, resided in White Plains, New York, to terminate her tenancy and evict her therefrom. Sanders, Glendora says, omits the proof Glendora submitted. 7 audio tapes of Esteves harassments, all in violation of the Emergency Tenant Protection Act, which amounted to $12,000 in fines. A summary proceeding in White Plains City Court for eviction is also a violation of the Emergency Tenant Protection Act, the ETPA. Point theta. Cohen respondent's lawyer write, by letter dated March the 30th, 1993, the division advised plaintiff that after investigating her complaint, the agency determined that the file should be closed for the following reasons. 1, plaintiff signed a general release on November 18th, 1 month after filing the administrative complaint, releasing Mr. Esteves from liability. This is wrong, for the same acts previously alleged as harassment in exchange for $5,350. They paid me $5,350, which was the amount of overchange that Esteves, the overcharge that Esteves made against the ETPA, and Glendora refutes all this. Glendora never released Esteves from the harassment and the harassment charges she had against him before the William Street DHCR. The Cohen respondents were entirely outside any such release. They were not a party to any such release. Any such release was beyond their domain. Davis lawyer Chris Johnson lied to the William Street DHCR that Glendora had lied to the White Plains DHCR. This is libel on the part of both Johnson, Davis, and the White Plains DHCR. That would be David Ayala, Fernandez, and Carol Short, if there was any such claim by the White Plains DHCR. 4. Chris Johnson obtained this release under fraudulent coercion. Point iota. Cohen respondent's lawyer Sanders Wright. 2. Plaintiff vacated the subject premises on November 30th, 1991, approximately 1 year prior to filing the administrative complaint and signing the general release. And Glendora says to that, this is another lie. We taxpayers, including you 4 judges and including you folks, are paying salaries to write. We are paying the salaries of Charles Sanders to write lies, just as we paid the salaries of the people at the DHCR, that would be Lazaro Francisco, to lie. It was less than a year that Glendora filed the harassment charge with the William Street DHCR, because after she filed the harassment charge with the White Plains DHCR, that unit, in its terminal negligence, kept the complaint several months before telling Glendora that all harassment complaints had to be filed with the William Street DHCR. Cohen respondents and lawyer Sanders are not writing a statement of facts, they are writing a statement of lies. Point kappa. Cohen respondents lawyer Sanders Wright. And 3. The City of White Plains issued a resolution on September 9th, 1992, removing renters of owner-occupied co-ops and condos, such as plaintiff, from the protection of the Emergency Tenant Protection Act. Glendora writes, the White Plains Common Council passed this rule about 8 months after Davis had committed the last harassment in November of 1991, and at least 17 months after Davis committed the first of the 12 harassments. The White Plains Common Council did not make this rule retroactive. Cohen respondents lawyer Sanders Wright, thereby causing division officials not to process such cases until a policy is formulated dealing with the jurisdictional issue raised by this resolution. You see how lawyers get paid? And this is a New York State lawyer. This is an assistant attorney general. He's lying, he gets paid to lie, and we pay him. Case, you can see how the lawyers get paid for lying. That's the lawyer's living, lie. Glendora replies, 1. Cohen defendant's lawyer Sanders did not raise this point to Judge Coppola in the lower court and hence are precluded from raising it in the appellate division. 2. Cohen respondent's lawyer Sanders offered no citation, nothing in writing that the jurisdictional question is so. And with their record, it is probably not so. Point lambda. Cohen respondent's lawyer Sanders writes, by letter dated April 1st, 1993, the division further advised plaintiff that no further enforcement action concerning her complaint was presently warranted because the plaintiff, tenant 1, quote, was not subject to the rent regulatory laws and therefore not within our jurisdiction, and 2, signed a general release. Glendora replies, yes, the letter was written, but the letter was full of lies. Again, we taxpayers are paying salaries to these tortfeasors, all of them. It is time they got due punishment. Point mu, another lie in the statement of facts. Cohen respondent's lawyer Sanders Wright, by summons and complaint dated August 2nd, 1993, plaintiff brought this action in New York State Supreme Court, Westchester County, against the state defendants. Glendora replies, no, not against the state defendants, against Stephen Cohen, Myron Holtz, Gary Friedland, the William Street DHCR, John Wallach, Veronica Diaz, and the Queens DHCR par docket. That's, and by the way, the par docket number is 6K 910008HL, not to be miscalled the state defendants. State defendants is a manipulation and a cover-up. These are people, they are accountable. Point new. Cohen respondent's lawyer Sanders writes another lie, unspecified. Pursuant to unspecified statutes alleging that the state defendants negligently handled the harassment complaint and inflicted emotional distress upon her during the period November 1990 to November 30th, 1992. Glendora writes, everything in her complaint was specified. Each negligence was stated. And each was stated with proof, mountains of proof. Negligence, 19 counts, is a New York tort. Point Xi, Cohen defendant's lawyer Sanders offered no proof at all. Point Omicron, Cohen respondent's lawyer Sanders right. Plaintiff sought monetary and punitive damages in the sum of $50,000. The state defendants thereafter moved to dismiss the complaint on the grounds that plaintiff failed to state a cause of action. That's a recorded announcement. You don't have to go to law school 3 years. Just read CPLR 3211, 7A7. To state a cause of action in the Supreme Court lacks subject matter jurisdiction over the alleged claims, since plaintiff essentially sought monetary damages against the state of New York. Glendora says to this lie. 1. And both defendants' lawyer and Judge Coppola were wrong to claim Glendora failed to state a cause of action. She stated a cause of action, negligence, 19 counts, and negligent infliction of emotional disturbance with no physical effect. Defendant's lawyer never offered any proof that they did not commit said negligences. 2. Both defendant's lawyer and Judge Coppola were wrong in claiming the Westchester Supreme Court lacked jurisdiction and that Glendora's complaint belonged in the Court of Claims. Every week, the New York Law Journal reports decisions by the New York Supreme Courts where the DHCR has been convicted of damages and has been ordered to pay. See pages 114, 115, 132, 137, 142, 143, 149, and 157 of the Record of Appeal, my Record of Appeal. Point pi. Respondent's lawyer are repetitive. Plaintiff cross-moved for monetary damages and to dismiss the state defendant's motion. By order and judgment entered on October 29, 93, the Supreme Court Judge Coppola granted the state defendant's motion, denied plaintiff cross motion, and dismissed the complaint. Glendora, they already said this, and the appellate division has rules against repetition. Point roll. Respondent's lawyer right. The court found that the complaint fails to set forth a legally cognizable claim sounding in negligence as against the moving defendants. Glendora replies, this is a recorded announcement. It shows no due deliberation on Judge Coppola's part. It was probably written by his ill-tempered law clerk. It is why his bad decision is being appealed. Point sigma. Respondent's lawyer repeat, moreover, the court lacks subject matter jurisdiction to award money damages against these defendants. The Court of Claims is the appropriate forum, therefore. Glendora replies, Glendora has already shown many times how the DHCR is sued in New York Supreme Courts, has lost, and has been ordered to pay damages. And Glendora is showing that respondent's lawyer's statement of facts is a statement of lies. They have sold their souls. Point taw. Plaintiff appellant Glendora refuses again repetitious lies, refutes again repetitious lies of Cohen respondent's lawyer Sanders. Argument point 1. Plaintiff failed to state a valid cause of action against the state defendants. In her complaint, plaintiff alleges that the state defendants negligently caused her unspecified injuries by failing to act upon harassment charges. Glendora replies, injuries were specified very plainly in Glendora's complaint. See the Record on Appeal, pages 11 to 91, with profuse documentation and proof. No proof, no documentation has been provided by defendants' lawyers. Defendant's lawyer writes, this allegation as a matter of law fails to state a valid cause of action against the state defendants. This is a lie. Glendora replies, it is a recorded announcement. Glendora does have a robustly valid cause of action against respondents Cohen, Holtz, Friedland, the William Street DHCR, Wallach, Diaz, and the Queens DHCR. Defendants have no meritorious defense, and a good judge would have seen this. Point upsilon. Respondent's lawyer Wright, in order to prove a prima facie case of negligence, a party must establish the existence of a duty on the part of the defendant to him and a breach of that duty. And then he quotes Boltax, Solomon, and Akins, and Glendora replies, the duty of the DHCR to enforce the ETPA has long been established. Defendants have no meritorious defense. Glendora has extensively shown in her cross motion, see the record on appeal, pages 116 to 137, that these citations do not support respondent's lawyer's case, that they are irrelevant in some cases, that they are for Glendora, and against respondent's lawyer in many cases, and that they are overworked, worn down by repetitive past computer use for the last decade. Point 5, respondent's lawyer Wright. Here the state defendants do not have any duty to prosecute plaintiff's harassment charges. No statute or regulation imposes such a duty. Plaintiff was not covered by the state rules and regulations which requires the division to prosecute such. Glendora replies, all these respondents had a duty to enforce the harassment orders of the Emergency Tenant Protection Act, ETCPA. See the record on appeal, page 28. So here, taxpayers pay the salaries of negligent people who fail to do their job, which is to enforce the ETPA, the Emergency Tenant Protection Act. Glendora is sending the record stated in her complaint, the record on appeal, appellant's brief, respondent's brief, and reply brief to George Pataki to see if we can rid the citizens of such liars and negligent taxpayer robbers. I'm afraid that Cuomo's agencies are in a bad shape. Here's the assistant district attorney lying. Here's the DHCR negligent. The first DHCR case, the second DHCR case. And then, what was that other agency that we found was so negligent? The other Cuomo agency. Of course, you have the whole court system, which is a mess. So we really need a change of administration. Point Chi. Oh yeah, the other agency that's so bad, the New York State Cable TV Commission. Point Chi, at the time the 12 harassments were committed by landlord Estavas, the ETPA applied to Estavas. Respondent's lawyer are wrong in writing infra. Acts since the plaintiff, A, did not reside in housing regulated by the DHCR. Point Psi. The release, A, did not apply to the harassment law breaking. B, was outside the domain of the DHCR and should be defended by the landlord, not by the DHCR. The state of New York should not be paid for defending Estavas coercing and fraudulent release. And C, was fraudulently obtained and was coercion. In addition to lying, respondents Cohen et al. Show they are pro-landlord and anti-tenant. The ETPA was written and approved by the state legislature to protect tenants, not landlords. Point Omega. Glendora did this precisely. Sanders writes, moreover, to maintain her action against each individual state defendant, the plaintiff must show that individual is responsible for the alleged injury and that the award of prospective relief against them will remove the alleged harm. That's precisely what Glendora did. Respondents Cohen, lawyer, Sanders write, no such authority exists for such a contention. Glendora replies, see the record on appeal, pages 11 to 91, pages 111 to 138. Infra, you have a false premise upon which a faulty conclusion is built. The point falls, the conclusion fails. The individual state defendants, they write, are not empowered to review a harassment charge brought by a tenant against a landlord if the subject premises is not regulated by the division. Glendora refutes this repetitious and abusive assertion. When the landlord committed 12 harassments, the White Plains Common Council had Bryant Gardens under the Emergency Tenant Protection Act, the ETPA. This statute The status continued for 8 months after the harassments were committed and after Glendora brought her complaint to the DHCR. Respondent's lawyer tell the same wrong over and over. They waste the time of you 4 judges, the appellate division. Point alpha alpha, more faulty conclusions. Respondent's lawyer right, since none of the individual defendants could enter an order to direct the division to grant the relief the plaintiff seeks herein, they could not, as a matter of law, be liable for negligence for failing to do so. Glendora replies, these individual defendants could have and should have entered the order, obeyed the ETPA, fulfilled their duty, and kept their public trust. Their performance is negligent to the core, so is that of their lawyer. Accordingly, Glendora should be granted her $50,000 relief in costs, and the state should be rid of Cohen, Holtz, Friedland, Wallach, and Diaz, who are responsible for these negligences, just as the state is now rid of Aponte and should be rid of Cuomo. 2 lies lie in the sentence that follows. Accordingly, this is by the defendant's respondent's lawyer. Accordingly, the complaint failed to set forth a legally cognizable claim sounding in negligence against any of the state defendants. They are not state defendants, 1, Glendora says. They are individuals who committed these negligences and who are accountable. 2, and negligence, a tort, is a legally cognizable claim. Point beta beta. None of the above arguments in respondent's lawyer's brief appeared before Judge Coppola. This is not right, this is not proper. Point gamma gamma. Glendora refutes again repetitive and abusive point 2 of tortfeasors. This is their point 2. The Supreme Court lacks jurisdiction over the complaint because it is essentially an action against the state for money damages. How many times has he said this? About 6? The state of New York, he writes, is subject to suit for damages only in the Court of Claims. Moreover, actions against state employees acting in their official capacity in the exercise of governmental functions are deemed to be, in essence, claims against the state, and therefore suable only in the Court of Claims. And Glendora replies, the New York Law Journal reports every week, case after case, of people suing the DHCR, of state Supreme Courts ruling against the DHCR, and of state Supreme Courts ordering the DHCR to pay damages. See the record on appeal, pages 114, etc. Point delta delta. Respondent's lawyer right. The individual state defendants here are sued in their official capacity as division employees. Thus the claim is essentially against the state of New York, as is the claim against the division. Glendora protests. Cohen, Holtz, Friedman, Wallach, and Diaz committed the tortious acts. They are solely responsible. They are totally accountable. Is this the kind of America that the people died in D-Day for? Here they are. They committed all these negligences, and now they want to blame it on the state of New York. Is this the kind of America that we fought and died for? Torts have many tools, but a lie is the handle that fits them all. These people cut out a very bad record to be read on television, and that's to you now. Since the state is therefore the real party in interest, plaintiff's claim, Sanders' right, for monetary damages can be brought only in the Court of Claims. Point epsilon, epsilon. Glendora protests. This is not how the New York Law Journal reports it. See the record on appeal, pages 114, 15, 132, 37, 42, 43, 49, and 59. Respondents' lawyer Sanders continue with their lie. The Supreme Court does not have jurisdiction over the action, and it properly dismissed the complaint. And Glendora replies, the state Supreme Court does have jurisdiction. This is just another escaped attempt to dump a case out of one court to get rid of the workload by dropping it into another court. Judges do that all the time. They drop these cases into other courts to get rid of them. It is against the trust, the raison d'etre, the oath of office, and the paycheck. The case was improperly dismissed. If Judge Coppola had no jurisdiction over the complaint, where did he get the jurisdiction to dismiss it? Point zeta zeta, the conclusion fails because the premise falls. Conclusion, Sanders writes, for all the foregoing reasons, the order and judgment of the court below should be affirmed. New York, New York, June 17, 1994. G. Oliver Capel, Attorney General of the State of New York, Attorney for Defendants Responders, Charles F. Sanders, Assistant Attorney General of Counsel. So that's what we are doing, paying the Attorney General of the state of New York to tell lies. And Glendora replies, see up here he says, for all the foregoing reasons. Well, Glendora says lies, quote unquote, cannot qualify as reasons. The judgment is wrong, it is unjust, it should be reversed. Point Eta Eta, this page should not have been left in respondent's brief to Glendora, to appellant Glendora. This is Sanders' affidavit of service, and it shouldn't have been in here. Even filled in, it shouldn't have been in here. Certainly it shouldn't have been filled in here empty. Point Theta Theta, respondent's lawyer did not refute any of plaintiff appellant's 38 points made in her brief. Therefore, Glendora should win this appeal by default. You remember the 38 points in my brief. I read my appellant's brief. I read them to you before it was submitted. Conclusion of plaintiff appellant Glendora. Since neither Cohen, nor Holtz, nor Friedland, the William Street DHCR, Wallach, Diaz, the Queens DHCR, nor Sanders addressed or opposed any of the 38 points of her argument stated in her appellant's brief, and since these same respondents and lawyer told nothing but lies in their respondent's brief, Glendora's appeal is unopposed for the 38 reasons she gave in her appellant's brief, and Judge Capola's decision should be reversed, and Glendora should be granted A, $50,000 for 19 negligences, B, $445 cost for this action, $245 for the index number and the request for judicial intervention, and $250 for the request for appellate division intervention. And any further relief this court deems just and proper. Dated White Plains, New York, July 25th, 1994. Yours in truth, Glendora, Box 416, White Plains, New York, 10602, 914-949-9495. And it's peach. Almost maxed, it says peach. But things are not peachy. Named Darrell asked his daddy, he says, Daddy, does the husband boss the house? And Daddy says, no, son, the husband houses the boss. The phone rang in the maternity ward, and an excited man said, this is Charles Patterson, and my wife's about to have a baby, and I'm bringing her in right away. And the nurse says, calm down, calm down. Is this her first baby? And the man says, no, I told you, this is Charles Patterson. That's the end of Glendora versus the DHCR, Stephen Cohen, Myron Holtz, Gary Friedland, the William Street DHCR, John Wallach, Veronica Diaz, Queens DHCR, and the other DHCR case, the two bad Capola decisions. That's the end of that for a year and a half, because the appellate division is a year and a half behind in their oral arguments, and I won't be called to argue this orally for a year and a half, and I bet you they will group these two just the way they grouped the three Glendora versus Gallicano cases, which is a bad practice. It's not a good idea at all. If they're going to do that, then they should give you two for $250 or 3 for $250, because you go out and you pay $250 to the appellate division for each of these. And so if they're going to group them all together, then they should give you 2 for $250. They should give you a discount. As I said to you before, the courts are the worst consumer ripoff in America today. And my word for the courts is wandering through purgatory and wandering through hell. The Divine Comedy by Dante. Now, the three oral arguments that we had before the appellate division on June the 16th, 1994, remember 789? Okay, the 3 decisions come out. And every one of those decisions, the bad decision of Nikolai, the bad decision of Ruskin, the bad decision of Judge Donovan, all 3 of those bad decisions were affirmed by the appellate division. They didn't even deal with the issue of the case, the appellate division. And this is my TV report on the same. July the 22nd, 1994, Friday, TV report on the appellate division, decisions on Nikolai, Ruskin, Donovan, all bad decisions, to Glendora's TV audience, that's you, and to others. Son-in-law lawyer Ornberger submits a motion to dismiss and does not buy an RJI. So the motion just sits there going nowhere. The 20-day due date to answer the summons comes and goes. The motion just laid there and went nowhere. Ornberger, Gallicano obviously defaulted. Glendora moves for default motion and buys the RJI. Donovan denies it. Donovan breaks the law and the appellate division condones it. Isn't that terrific? 2. Ornberger argues that Glendora loses because of res judicata and collateral estoppel because Judge Holden in the White Plains City Court rules in favor of Gallicano. While the briefs sit in the appellate division for 1.5 years, the appellate term turns the Judge Holden decision upside down and says Glendora wins, Gallicano loses. In the oral argument, Glendora tells the appellate division this: Rosenblatt, Ritter, Santucci, and Miller. And they rule that Glendora loses the appeal because of res judicata and collateral estoppel. Is that intelligent? 3. Question: who made these 3 bad appellate division decisions? Was it the judges or was it some summer employee? Law clerk, fresh, too fresh, out of law school. Or was it even lower? Was it an intern? 4. Glendora shows that this happens. She knows that it happens. She read it several times in the Pace University Law School Bulletin to prospective students. Judicial clerkship externship. Quote, this woman, Jerry Gardner, wrote, I took the judicial clerkship during the summer and it was wonderful. I would spend every day with the judge, observing him in the courtroom, and then attend a weekly seminar. The judge's clerk assigned me to handle things the judge needed to have done, such as researching memorandum of law or writing opinions. It was very exciting when the judge used in court a lot of the things I had written. One case turned out an environmental statute. The judge was very happy to have my input. Since there aren't that many environmental law specialists out there today, it worked out very well. The clerkship gave me a lot of insight into the court system. You're getting that too, aren't you? It was exciting to use things I was learning and also to learn some things you can't learn from a book. Well, I take her quote, learn so much you cannot learn in books. Okay, quote, such as, judges love to have law clerks do their work for them. In fact, anybody they can get to do their work for them. One judge told Glendora about law clerks writing the decision. In fact, when I told him that law clerks write the decisions, he never denied it even. And this is what he said. I tell my law clerk, look, here's what I think, and I think it should be in there. Now, how's that? The truth is out. Only Rosenblatt looked at Glendora during the oral argument. He was the only one who showed eye contact. Santucci, Miller, and Ritter all kept their eyes down and refused an eye contact. Santucci did this during the oral argument in Brooklyn when he and Florio, Goldstein, and Sullivan made the bad ruling that Gannett did not commit libel. Santucci has a sourpuss and will not look at Glendora. The appellate division should not have bunched 3 oral arguments all in one day the way they did June 16, 1994 in White Plains. Or they should have given Glendora a discount. Glendora had to pay $250 for each of those appeals times 3 equals $750. She had to write 3 separate appellant's briefs. She had to write 3 separate reply briefs. It is too much to review for 3 of them. It is too hard to argue them for 3 of them. Or at least the appellate division should have given Glendora a discount price, maybe 3 for $250. Then there was the printing costs on them, $500 a piece, $1,500, and they called them 6, 7, and 8. Why was 6 mad at 7? Because 7, 8, 9. PJ, Presiding Justice Rosenblatt, when Glendora told him the appellate term overturned Judge Holden's decision and that it was goodbye to the res judicata claim, asked Ornberger if he knew the decision was overturned. Ornberger said yes, and the appellate division writes the dumb decision denied because of res judicata. Figure that one out. Then it was like pulling teeth to get crooked landlord and son-in-law lawyer to pay the $1,580 awarded Glendora by the appellate term. Glendora had to send the sheriff after them 5 times. Finally, they paid the $1,580. At the time of the oral arguments they paid shows they were lying in all their pleadings before these 3 judges and all their briefs before the appellate division. Glendora is sorry about the typos, but she does not have time to go back and correct them. This report is to be read on TV, not written on TV. As somebody said to Glendora when she told them about the bad work of the appellate division, quote, "I just don't understand. I just don't know how they do it. I just don't know how they do it." That is certainly true. It is an enigma. It is an enigma. Let's try that again. It is an enigma. What can you expect of a court that goes by the date received of the appellant's brief and not by the date posted the way they go on everything else? Then accepts a respondent's brief and an appellant's brief reply, no matter how late it is beyond the rules, and is 18 months behind in its oral arguments, and has no oral arguments in July and August every year. Answer? Not much. And certainly not justice. That's the last thing you can expect. 12. The U.S. Court of Appeals, within a week of getting the notice of appeal, orders the district court, analogous to the Supreme Court, to get out the record on appeal in a week, the appellant to have the brief in a month, the respondent to have the brief in the next month, any reply brief in within a half a month, and an oral argument within a half a month after that. That's more like it. That's the United States Court of Appeals down in Manhattan, Foley Square. The appellate division is 1.5 to 2 years. Folks, do not first of all look for justice in the city courts or the town courts or the New York Supreme Court. You will not find it there. Then after that, do not look for justice in the appeals court. You will not find it there.